Simon Ekpa's trial resumed at 12:30 p.m. with the presence of Simon Ekpa, his legal team, and the prosecuting counsel, who introduced their fourth witness, an officer from the National Bureau of Investigations. The fourth witness testified that he led the investigation against Simon Ekpa, claiming they uncovered substantial evidence within 4 months and brought duplicates of the documents, promising to provide originals if required. The fourth witness labeled Simon Ekpa a terrorist during his testimony, sparking outrage from Simon Ekpa and his legal team. Simon Ekpa's lawyer objected to the line of questioning and requested that Simon Ekpa be allowed to speak. Simon Ekpa delivered an emotional speech, asserting his innocence, decrying the injustice of being called a terrorist, and expressing hope that the truth would prevail. His calm and heartfelt address left the courtroom silent. Simon Ekpa's lawyer requested cross-examination rights, which the judge granted, affirming that the accused has a legal right to challenge witnesses and the evidence presented. Simon Ekpa directly questioned the fourth witness, challenging the validity of the accusations and pointing out that expressing frustration online or political opinions should not be misconstrued as terrorism. The fourth witness presented several exhibits, including transcripts of encrypted messages, Exhibit A, financial transactions linked to alleged extremists, Exhibit B, online network analyses, Exhibit C, and indirect links to violent attacks, Exhibit D. Simon Ekpa refuted all accusations, stating that messages were hypothetical, money transfers were for business, and online posts were opinion-based. He emphasized there was no direct evidence linking him to violence or extremism. Simon Ekpa argued that influence is not a crime, and unless direct incitement is proven, expressing dissenting views or opinions online should not qualify as terrorism under the law. The hearing ended with anticipation, as the court announced plans to present official documents in the next session. The courtroom in Helsinki, Finland, was cloaked in a strange tension on that day when the trial of Simon Ekpa resumed. The proceedings had already drawn much attention both in Finland and internationally. As the clock struck 12:30 p.m., the judge called the court into session, and all eyes turned towards Simon Ekpa as he took his place beside his legal team. His demeanor was composed, yet his eyes carried the weight of a man burdened by the seriousness of the accusations leveled against him. Simon Ekpa, known as a separatist advocate and political activist, faced charges that linked him to alleged terrorist activities, and on this day, the trial reached a particularly dramatic chapter. In the courtroom, seated with purpose and authority, was the prosecuting counsel, a man who had so far handled the case with steely professionalism. He now stood and introduced the fourth witness for the state, a high-ranking officer from Finland's National Bureau of Investigation. This officer was tasked with leading the investigative team that had worked on Simon Ekpa's case for several months. The officer walked to the witness stand with quiet confidence. His face was firm, and his posture suggested someone who believed deeply in the legitimacy of the evidence he was about to present. As the officer was sworn in and began his testimony, he stated that he had personally overseen the operation that investigated Simon Ekpa for nearly 4 months. He claimed that during this time, his team had gathered what he described as substantial and undeniable evidence pointing to Simon Ekpa's involvement in activities that, according to Finnish law, fell under the definition of terrorism. He explained that his team had come prepared with duplicate copies of all the documents they had gathered during their investigation, and added that the originals could be brought forward should the court request them. What followed next was a moment that transformed the courtroom atmosphere from tense to explosive. The officer, while speaking with a sense of detachment expected of someone in his position, referred to Simon Nyoku Ekpa as a terrorist. The word reverberated through the courtroom like a thunderclap. Simon Nyoku Ekpa, who until then had maintained a relatively calm presence, visibly stiffened. His legal team reacted immediately and sharply. One of his lawyers rose to his feet and raised a strong objection. The lawyer argued that it was not the role of a witness to assign guilt, especially in such definitive and damning terms. The term terrorist, the lawyer contended, carried a moral and legal weight that could unfairly prejudice the court and the public against his client. The judge, a composed and experienced woman who had overseen many high-profile trials, acknowledged the objection. She reminded the courtroom that the presumption of innocence must be upheld and that guilt or innocence would be determined by the court based on the entirety of the evidence and arguments presented. At this point, Simon Nyoku Ekpa requested to speak. His legal team supported the request, and the judge, after a moment's consideration, allowed it. Simon Nyoku Ekpa stood up slowly. He looked across the courtroom, taking a long breath before he began to speak. His voice, calm yet filled with a quiet intensity, carried across the room. He began by saying that he had always believed in peaceful advocacy and had never encouraged or engaged in violence. He expressed his heartbreak and disbelief at being labeled a terrorist. He said that for months he had watched as his image was tarnished and his intentions misrepresented. He maintained that his activities were centered on advocacy, communication, and drawing international attention to what he considered the suffering and marginalization of his people in southeastern Nigeria. He said that he was being punished for his voice, for his words, his opinions, and his expressions online. He looked directly at the judge and stated that he had not committed a single act of violence, nor had he incited others to do so. His speech struck a chord. The courtroom, which had been filled with murmurs and tension earlier, fell silent. Even the presiding judge watched him closely, visibly moved by the composure and sincerity with which he delivered his address. Simon Nyoku Ekpa ended his statement by saying that he believed in the justice system and that he hoped this court would look beyond the surface and examine the facts carefully. He expressed hope that the truth would come to light and that justice, not prejudice, would prevail. The silence in the courtroom lingered for a few seconds after he finished, as if everyone present was absorbing the gravity of what had just been said. Following the emotional statement, Simon Nyoku Ekpa's lawyer stood up once more to make a formal request. He asked the court for the right to cross-examine the witness who had just testified against his client. The judge, maintaining her commitment to due process, granted the request, stating clearly that the defense had every legal right to challenge the testimony and the evidence presented by the prosecution. What followed was a tense but controlled exchange between Simon Nyoku Ekpa and the fourth witness. Taking the role of cross-examiner, Simon Nyoku Ekpa asked precise and pointed questions. He began by challenging the foundational claim that he had committed acts of terrorism. He asked the officer if any direct evidence had been found tying him to the planning or execution of violent acts. The officer replied by citing a series of exhibits. The first was Exhibit A, which consisted of transcripts from encrypted messaging applications. According to the officer, these messages contained language that hinted at strategic coordination and the sharing of sensitive information. Simon Nyoku Ekpa, after glancing through the transcripts, countered that the messages were hypothetical discussions, often shared in private and taken out of context. He said that he, like many politically active individuals, sometimes exchanged thoughts and theories with colleagues, but these were academic in nature and never intended to be taken as plans for action. Next was Exhibit B, which included records of financial transactions. The officer claimed that some of the funds had been traced to individuals and entities that were under suspicion for extremist activities in Nigeria. Simon Nyoku Ekpa responded that the financial transactions were tied to his media and consultancy businesses. He explained that many of his financial dealings were related to payments for interviews, speaking engagements, and partnerships with content creators. He firmly denied ever sending money to anyone with the intent of funding violence. Exhibit C was perhaps the most technical. It involved online network analysis reports that supposedly showed how Simon Nyoku Ekpa's digital content was shared and circulated within communities linked to radical ideologies. Simon Nyoku Ekpa did not shy away from the complexity of this evidence. He acknowledged that his content reached many people and that once something is published online, it is nearly impossible to control where it ends up. However, he stressed that being influential or having a wide digital reach should not be construed as criminal. He said that there are countless influential voices around the world whose content inspires protest or resistance, but this does not automatically translate to violence. Finally, Exhibit D included reports of violent attacks that occurred in Nigeria, where individuals who had reportedly consumed Simon Nyoku Ekpa's content were allegedly involved. The officer admitted that while no direct link could be proven between the attacks and Simon Nyoku Ekpa, the timing and narrative of his posts raised suspicions. Simon Nyoku Ekpa seized on this point. He said that correlation does not mean causation. He insisted that unless there was a direct order or incitement from him that led to an act of violence, such claims remained speculative at best. He told the court that if expressing dissent or criticizing governments online constituted terrorism, then a vast number of journalists, activists, and even academics would be guilty. He said that true justice requires distinguishing between speech and action, between influence and incitement. He concluded by saying that ideas are not bullets and opinions are not bombs. Throughout the session, the atmosphere remained charged. Every exchange between Simon Nyoku Ekpa and the officer was closely watched by those present. Occasionally, the public gallery murmured, especially during emotional or revealing moments. The judge had to caution the audience to maintain silence several times. As the hearing neared its end, the judge addressed both parties and stated that the next session would include the presentation of official documents related to the case. These documents were expected to offer more clarity on the sources and nature of the evidence gathered during the investigation. The judge thanked both legal teams for their cooperation and reminded everyone of the importance of fairness and respect for the legal process. Simon Nyoku Ekpa's legal team left the courtroom quietly, speaking in hushed tones among themselves. Simon Nyoku Ekpa remained solemn, but appeared more composed than he had at the beginning of the day. Supporters of Simon Nyoku Ekpa, who had gathered outside the courthouse, held placards and chanted slogans in support of him, calling the trial a witch hunt and demanding his release. Inside the courtroom, the tension had not entirely lifted. The accusation of terrorism had already made global headlines, and public opinion remained divided. Some believed that Simon Nyoku Ekpa was being targeted for his political views, while others believed the court had a duty to probe deeper into his influence and activities, especially given the complex situation in southeastern Nigeria, where violence had increased in recent years. In the days that followed, media coverage of the trial intensified. Analysts weighed in from various parts of the world. Some legal scholars noted that the case posed a significant challenge in defining the limits of free speech in the digital age. They questioned whether advocacy for self-determination and political reform, even when expressed forcefully, should fall under terrorism laws. Others highlighted the importance of prosecuting anyone whose influence directly leads to violence, warning that ignoring such patterns could embolden extremist behaviors online. As the court prepared for its next session, there was an unspoken understanding that the trial was no longer just about Simon Nyoku Ekpa. It had become a larger conversation about justice, speech, responsibility, and the very definition of terrorism. The courtroom would soon reconvene to hear more arguments and examine more evidence. Until then, the fate of Simon Nyoku Ekpa hung in the balance, resting on the ability of the legal system to see through the noise and arrive at the truth. As the sun rose on the following day in Helsinki, Finland, the world outside the Finnish courtroom seemed relatively calm, but within the walls of the courthouse, the tension was far from over. The case involving Simon Nyoku Ekpa had already gripped the attention of not only the Finnish media, but international observers as well. Journalists from Nigerian media outlets had flown into Finland, joined by representatives from several international human rights organizations, legal watchdogs, and foreign correspondents. They had all gathered to witness what was gradually shaping into a historic courtroom drama with implications far beyond the Finnish legal system. When court reconvened at exactly 9 a.m., the air inside the courtroom felt heavier. People whispered among themselves. There was a sense that something critical was about to unfold. Simon Nyoku Ekpa walked in accompanied by his legal team. His steps were slow but deliberate. His eyes scanned the gallery briefly. There were familiar faces, supporters who had come all the way from Nigeria, Finnish citizens curious about the case, and members of the press who scribbled notes and adjusted their recording equipment as he passed. The judge entered the courtroom shortly after, and proceedings began with a formal statement. She explained that the day's hearing would be dedicated to examining official documents submitted by the prosecution. These documents, she emphasized, would be treated with full legal weight and would help determine whether there was credible evidence tying Simon Nyoku Ekpa to any acts of terrorism or unlawful political activity as defined under Finnish law. The first document presented was an interagency report compiled through collaboration between the Finnish National Bureau of Investigation and the Intelligence Division of the Nigerian Police Force. It detailed a chronological list of activities and communications that occurred within a defined timeline. According to the prosecution, these entries painted a picture of a coordinated effort to destabilize parts of southeastern Nigeria through online rhetoric, financial support, and digital networks. The report also included testimonies from confidential informants, some of whom claimed to have interacted with Simon Nyoku Ekpa's broadcasts and interpreted them as calls to action. The defense immediately raised concerns over the use of anonymous sources. Simon Nyoku Ekpa's lead attorney, a tall, sharply dressed man with an eloquent tone, addressed the court with caution and determination. He reminded the court that anonymous testimonies, particularly those coming from jurisdictions outside Finland, must be treated with extreme scrutiny. He argued that intelligence agencies, especially those operating in politically unstable environments, often produce information that is politically motivated or outright manipulated. He asked the court to weigh such documents carefully, noting that if the court failed to maintain a high evidentiary standard, it risked turning the trial into a political theater rather than a legitimate legal proceeding. The judge nodded in agreement, stating that while the documents would be reviewed in full, The court would not draw any conclusions based on unverified testimonies unless corroborated by concrete and independent evidence. This is the end of our news update. Please click the icon on the top right corner of your screen to watch my next video. You will enjoy it. I will see you again in my next update. Enjoy the rest of your day. Goodbye for now.